Our group project is on the Supreme Court case Kaler v. Kansas. James Kaler was the petitioner and the state of Kansas was the respondent. This case was granted writ of certiorari on March 8th of 2019. It was argued in front of the Supreme Court on October 7th of 2019, and it was actually decided on by the Roberts Court on March 23rd of 2020. The members of this group project are Zion Aki, Taylor Barrow, Rachel Palinki, Molly Caldwell, Tia Canada, Amaya Cooper, Britton Howell, Tucker Jackson, and Nicole Lopez Vargas.
The case of Kaler v. Kansas involves James Kaler petitioning the state of Kansas for their insanity defense law. James Kaler suffers from the mental illnesses of depression and obsessive-compulsive disorder. This made him an abusive husband and an estranged father. His marriage to his then-wife Karen Kaler began to fall apart around 2008. Also in 2008, Karen Kaler began an extramarital affair with another woman. Karen Kaler filed for divorce from James Kaler in January 2009. She moved out of the house with their 2 daughters and young son by that spring. James Kaler did not handle their divorce very well, and his mental health further deteriorated. In November 2009, Karen Kaler was spending Thanksgiving break with her children and her grandmother in Burlingame, Kansas. James Kaler broke into their house and shot his ex-wife, his 2 daughters, and his ex-wife's grandmother. For unknown reasons, he let his son escape the scene of the crime. All 4 victims of the shooting suffered fatal shots and died.
The day after James Kaler shot and killed 4 of his family members, he decided to turn himself into the police. The state of Kansas charged him with capital murder and aggravated burglary. Before his trial began, James Kaler argued that the state of Kansas violates the 14th Amendment's due process clause by allowing a mentally ill defendant to be convicted of a crime, even if this defendant did not have the ability to determine right from wrong at the time the crime was committed. James Kaler claims that the state of Kansas has unconstitutionally abolished the insanity defense. The court did not agree with this argument and denied his motion and proceeded with the trial like they normally would. Dr. Stephen Peterson, a forensic psychiatrist, presented testimony on behalf of the defense. He claimed that due to James Kaler's severe depression, he was simply unable to control his behavior at the time of the crime. However, the prosecution also had a forensic psychiatrist testify. Dr. William Logan stated that Kaler was most definitely capable of forming an intent to kill his 4 family members and was also able to even premeditate this crime. Since the Kansas law is primarily looking for whether or not the mentally ill defendant is capable of forming an intent to carry out their crime, the jury decided that James Kaler was guilty and convicted him of capital murder. At the sentencing stage, James Kaler continued to argue that his mental disease affected his behavior at the time of the crime. However, it was decided upon that he would be sentenced to death. James Kaler appealed this decision to the Kansas Supreme Court with the same argument that he presented before his initial trial. He argued again that the state of Kansas violates the 14th Amendment's due process clause by convicting mentally ill defendants who were not able to control their behavior at the time of the crime or able to determine right from wrong. The Kansas Supreme Court rejected his appeal and decided to uphold the lower court's conviction and sentence. Therefore, James Kaler used his last resort and appealed his case to the United States Supreme Court. He changed his argument a little bit and claimed that not only does the Kansas law violate the 14th Amendment's due process guarantee, but also it violates the 8th Amendment's prohibition of cruel and unusual punishment.
in regards to the issue of the case, currently, some U.S. states allow individuals to be exonerated of their crimes due to proof provided by medical experts showing signs of mental illness in the defendant. The individual can be exonerated for this crime because the defendant cannot comprehend whether the crime was morally right or wrong. This is referred to as the insanity defense. However, in the state of Kansas, the court system does not allow an individual to use this insanity plea to be exonerated from the crime they are on trial for. But the evidence of mental illness for the defendant can be provided by the defense to reduce the sentence of the individual or to allow for the individual to be admitted to a mental health facility where they will serve their sentence while being treated for their illness. However, this brings an issue that the defendants of Collar and Collar himself believe this statute in the state of Kansas is a violation of his 8th and 14th Amendments. The 8th Amendment states there should be no cruel or unusual punishment for citizens of the United States. And the 14th Amendment grants all citizens equal protection under the law and given a state's jurisdiction. For the decision of this case, the court ruled in a 6-3 vote in favor of Kansas, stating the statute in question is not in violation of the 8th or 14th Amendments. For the 6 justices who voted in favor of Kansas, these are Chief Justice Roberts, who was appointed by President George W. Bush, Justice Thomas, who was appointed by President George H. W. Bush, Justice Alito, who was appointed by President George W. Bush, Justice Kagan, who was appointed by President Obama, Justice Gorsuch, who was appointed by President Trump, and Justice Kavanaugh, who was also appointed by President Trump. For the 3 justices who voted in favor of Collar in this case, these are Justice Ginsburg, who was appointed by President Bill Clinton, Justice Breyer, who was also appointed by President Bill Clinton, and Justice Sotomayor, who was appointed by President Obama. In terms of ideology, the 6 justices who voted in favor of Kansas, 5 of which are conservative-leaning judges, hence being appointed to the court by all Republican presidents. The 1 justice who was not of conservative leaning is Justice Kagan, who was appointed by President Obama. Surprisingly, she is the justice who gave the majority opinion in this case. Along with her ideology are the 3 justices who voted in favor of Collar in this case, hence being liberal-leaning justices and being appointed by Democratic presidents.
The majority opinion in this case was delivered by Justice Elena Kagan. As Tucker previously mentioned, this was surprising to see her on the majority side with Kansas because she generally votes with the more liberal justices. It was unexpected to see her on the Kansas side and not on Collar's side with Ginsburg, Breyer, and Sotomayor. It was decided that the insanity defense be interpreted by the states, being they be the ones to examine and interpret the relationship between criminal culpability and mental illness. Therefore, the Kansas law was deemed not to be violating Collar's right to due process.
The Supreme Court clarifies that the state of Kansas has not abolished the insanity defense, as many believe, but simply removed the insanity defense from the trial process of determining innocence or guilt and shifted it to the sentencing process, which is allowed to be done under the United States Constitution. The reasoning given for the majority was explained by the fact that the insanity plea is not a fundamental right because it is not deeply rooted in American tradition.
The opinion of the court was decided using past rulings to justify their decisions in this case. The largest case used as a precedent for Collar v. Kansas is the 2005 case, Clark v. Arizona. In this most recent case regarding sanity pleas, the court ruled that the states could limit the amount of expert evidence used in a case. This decision favors Arizona's stance and regulates the amount of evidence allowed to display the mental state of the defendant. Another precedent for Collar v. Kansas was Leland v. Oregon, which upheld the constitutionality that the burden of persuasion will be placed on the defendant, which means that insanity must be proved beyond a reasonable doubt, leaving the Supreme Court to affirm Oregon's stance in this case. In addition to Clark v. Arizona and Leland v. Oregon, Powell v. Texas is also a precedent for this case. The court agreed with the state of Texas, leaving criminal accountability up to the states, while also deciding that alcoholics were not totally unable to control their alcohol consumption. Using the legal model, the court was able to use these precedents to determine that Kansas law was not violating any constitutional amendments. With these precedents, it's almost impossible for the court to decide any other way. The dissenting opinion was presented by Justice Stephen Breyer and joined by Justice Ruth Ginsburg and Justice Sonia Sotomayor. The main reason that the majority opinion decided for Kansas and upheld their decision was because they did not believe that the insanity defense was recognized under due process, since it was not so ingrained in American law as to be considered fundamental. However, Breyer claimed that the insanity defense should be protected by the 14th Amendment's due process clause. He claims that even though the states have the right to determine how they want to define the insanity defense, the idea behind all of their interpretations remain relatively similar, as they are all trying to protect the rights of those with mental illness. Most of the states use the Manhattan Rule to guide their interpretations of the insanity defense. The Manhattan Rule has two parts. The first part is clarifying whether or not the individual knew what they were doing when the crime was committed, and the second part is clarifying if the individual did know what they were doing at the time of the crime. Were they able to determine whether their actions were right or wrong? Under the traditional understanding of these rules, if a defendant can relate to at least one part of the Manhattan Rule, then due to the insanity defense, they should not be convicted of the crime they are being charged for. Justice Breyer provided an example showing how the traditional understanding of the insanity defense differs from Kansas's law. The first defendant shot and killed a person thinking it was a dog, and the second defendant shot and killed a person thinking that a dog demanded them to do so. Under the traditional understanding of the insanity defense that most states use, neither of these defendants could be convicted of the crime. The first defendant falls under the first part of the Manhattan Rule since the defendant thought the victim was a dog, and the second defendant falls under the second part of the Manhattan Rule since they thought the dog ordered them to kill the victim and did not know right from wrong. However, under the Kansas law, the government could not convict the first defendant, and they can only convict the second defendant of the crime. This example really puts into perspective how the Kansas law is interpreting the insanity defense and how it significantly differs from the traditional use of the insanity defense. Also, this example is showing how mentally ill individuals are having their rights deprived from them under the Kansas law.
Recalling Clark v. Arizona. The Supreme Court had ruled that a state can restrict part of the McNaughton Rule. Kansas pointed to this as their main justification for permission to eliminate the second part of the rule from their laws. However, Breyer argues that the insanity defense at its core was not eliminated in any significant way in Arizona. The inability to recognize whether one's actions are right or wrong are enough to demonstrate that one is not cognizant of their actions at the time of a crime anyway. Therefore, while eliminating the first part of the McNaughton Rule works for Arizona, the reverse does not work for Kansas. Furthermore, Breyer argues that what Kansas has done by moving their insanity defense to the sentencing phase of a criminal trial is wrong, as those who suffer from mental illnesses will be further stigmatized and can still face death as punishment for crimes they were not cognitively aware they committed. This decision defies American tradition.
The decision model used for Kaler versus Kansas was the legal model, and this is because the decision was based on precedent. Therefore, the court didn't base its decision off of opinion or ideology, and also justices' personal policy preferences were left out of the decision-making process. In the text, it provides a lot of explanation with previous rulings, such as Clark versus Arizona, Leyland versus Oregon, and Powell versus Texas. This case also used a constrained view, so the court is unable to accomplish significant change, and it's not a platform for social change. And as mentioned before, it based its decision on precedent, and also there's a lack of judicial independence.
Because of due process, Kansas is technically not required to adopt a sanity exam. The goal of a sanity exam is to see if the defendant comprehends the morality of the crime. Under Kansas law, the defendant can submit evidence of mental illness to show lack of intent and moral comprehension. But because judges have ruled insanity as a relief of punishment in cases dealing with insanity pleas, the court recognizes that under Kansas statute, mental illness can be used as a defense in Kansas. This being said, Kansas still finds moral incapability irrelevant to a plea of insanity and would not exonerate the crime committed. Even though delusions can affect the moral compass, the act committed in this case was done so consciously. Therefore, the individual can be punished without a violation to the 8th and 14th Amendment.
Ultimately, the final ruling for this case was that an individual may be held responsible for their crimes despite if they suffer from mental illness. This ruling may have negative reactions, including that some people may argue that this does not protect the mentally ill by putting them under no different circumstances than somebody who is not mentally ill. It may be argued that it is unfair to not address the difficulties with cognitive functions that may come with a mental illness. As for policy impact, this case concluded that there be no singular interpretation of the insanity defense and it instead be left up to interpretation by the states themselves. This case also may have influence on other states where they might use Kansas's interpretations of the insanity defense as their own. Overall, this case could also create a sense of fear among the mentally ill community too.
Further impact and analysis of this case include the reaction from the executive branch and from the legislative branch. Reaction from the executive branch is unlikely, as insanity defense is a state right and is not a major issue of the executive branch. This is something that was the premise behind the majority ruling for the case. Reactions for the legislative branch include the legislative branch cannot produce federal legislation on the insanity defense. Some individual representatives may introduce legislation at their constituents' support. State legislatures may introduce new legislation to interpret insanity defenses differently. These were the premises behind the majority opinion for the case, and were written in its defense.
And this concludes the end of the presentation. Because this case, Kaler versus Kansas, was recently decided on March 23rd, 2020, we as a group were able to use the court decision documents to get a full perspective on how the judges decided to vote for this case and their reasoning behind it. Thank you for watching.